come along now and say that no one knew I had the shares is just nonsense. It's an untenable position for them to continue to maintain. I gave full disclosure at all times in the shareholding, and partly because of that, suffered the anger from the marketplace when we in fact sold off the shares. So that's all I really want to talk about specifically regarding disclosure. So I think SAR's position that it's putting forward, that I've done everything I can to conceal, avoid, and just make sure they knew nothing about my trust. In fact, it's not correct. In fact, interestingly, if I had taken that approach, if I had lied in the prospectus and said, well, I'm going to pretend I'm not interested in the trust and kept it off the record, and in a funny way, I'd be better off. Because if I'd lied to the extent that no one knew about it, then when the amnesty came along, I could have applied. Because in reality, if you look at what I am being accused of in terms of exchange control and in terms of SARS, really what they're saying is you had offshore trusts. They were hidden. In which case, under normal circumstances, I would have applied for an amnesty, as every other South African was entitled to apply. But because they were aware of my trusts, they wrote me a letter saying, dear Mr. King, we're going to have an amnesty, but you don't qualify. You're not allowed to apply for the amnesty. You can't apply because, hey, we need someone. We need someone like you, a nice high-profile case where we think we can make an example of you, and that will ensure far greater compliance with the amnesty. Because absent that, I would have applied for the amnesty. And it's very difficult for SARS or the NPA, I think, to give an honest argument that what has happened to me in terms of my case is something that's of national policy interest. They can't really argue that. It's not like in the United States where you can say that on the back of Enron and what was happening over there, you get someone like Martha Stewart. And you look at Martha Stewart and you say, well, what did Martha Stewart really do? She got a phone call from her broker saying that, by the way, you've got shares in this company, the company's in trouble, the results are falling off. What did she do? She phoned and she sold the shares. Is it a legal infringement of the various acts? Yes, it is. But Martha Stewart was unfortunate at that point in time that America wanted to make an example of someone. Because under normal circumstances, if someone phones you and says there's trouble with the company, you'll sell the shares. I don't know if she's even aware of the regulations that she contravened, but at that time, America decided as a policy issue, it was a high-profile case, they could take advantage of it, and she went to jail for selling the shares. To argue in South Africa, in my specific matter, there's some policy issue around someone who's allegedly contravening exchange control regulations or who's allegedly not paying tax. We've had an amnesty for that. It's very difficult for South Africa to argue that there's some national policy interest. What is the policy in giving an amnesty to the whole country and choosing one or two people and saying you're not allowed to apply for that amnesty because we need to make an example of someone? Unfortunately, it was me. Hopefully the country did gain from it. And my understanding is they certainly gained probably many billions more because of the treatment of me, because people looked and thought, well, I don't want what happened to Dave King to happen to me. So if they were in any doubt about continuing with non-disclosure, I think the treatment of me was sufficient for them to cross the line and go the other way. The next point I want to move on to then is the litigation itself in the tax case. Now, by way of an introduction to that, I think that if one looks at the position of the Commissioner in litigation, the Commissioner is in reality bound by the South African Constitution. He is bound by the Constitution. And in terms of the Constitution, what is required of the Commissioner, it's the same with the NPA, it's the same with any public body, is that they approach litigation with the highest ethical standard possible. And it is not available to the Commissioner to go to the court on a tactical basis. He's actually just not allowed to do that. I think if we're litigating between one another, there is no problem with your attorneys saying this is an adversarial court situation. We're going to try and take tactical advantage of the situation, and you actually use the court and you try and maneuver the court to your advantage. The Commissioner is not allowed to do that. The NPA is not allowed to do that. In fact, if one looks at the behavior of the NPA and some of the other matters observed, one gains the impression that the NPA go out to secure criminal convictions. They go out to secure them. That's not what the law demands of them. What the law demands of the NPA is that they do proper investigation without fear, favour, etc., and they put their case before the court and let the court decide. It is not the job of the NPA to secure a conviction. It's their job to put it before the court. Now, I'm now into the area where I'm telling you I'm giving you my opinion this time. And I've invested a lot of money, 150 million rand in legal fees to some extent to get to this opinion. If I look at South Africa, in some ways I think personally it's unfortunate that we have the constitution that we've got. Because when we put our constitution together, we have got, I think, what's generally recognized as being the best paper-based constitution in the world. In other words, what the framers of the constitution did is they went along and they looked at the best constitutions in the world and they kind of pulled them all together and they get the very best of the best and they put that together and they said this will be the constitution for South Africa, Bill of Rights, everything that we require. The difficulty in my experience of that constitution is a number of things. Firstly, it's very clear to me that access to the constitution is only there for the rich. I've spent 150 million rand so far. I'll probably spend another 100 before it's finished. But I've got access to the Constitution. Why? It's very expensive to get there. If you haven't got the money, you don't get to the Constitution. So that's one thing. And the other thing is that it seems to me that if you've got a very advanced Constitution, but it has not arisen as a result of development, as it has in other countries, you just kind of buy it off the shelf, but you don't go through the developmental process, then you run some great risks. And the type of risk you run, by way of example, would be, if I take in SARS case, I take the pay now, fight later argument. The pay now, fight later argument where SARS can come to me and say, King, it's happened in my case. I got a tax bill for 900 million in 2002, and Ben Nevis, the company within the trust, got a tax bill for 1.4 billion. So we get tax assessments of 2.3 billion, and we were told to pay that same day. I was given till 4 o'clock to pay 2.3 billion to SARS. SARS then came along and say, well, you've got to pay now and fight later. Now, the principle of pay now, fight later is something that's been accepted by the South African courts. There was the Metro Cash and Carry case, so it has been accepted. And it was accepted on the basis that the pay now, fight later argument is not new to South Africa. It applies in the States, it applies in the UK, and in fact it applies in most developed countries. But what is critical to it is the Constitutional Court, in approving the pay now, fight later case, argued that while on the face of it, it doesn't appear to be constitutional. Because to go along to someone and say, I haven't proved the debt against you, but you have to pay me, and then fight to get your money back, particularly when you're paying SARS an amount of money which invariably includes 200% penalties plus interest, so invariably they're asking you to pay more than 100% of what you made, invariably. But the courts ruled that, as in these other countries, if you didn't have a mechanism available to SARS on the pay now, fight later basis, even though on the face of it was unconstitutional, then the whole fiscus could grind to a halt. Because people just wouldn't pay, they would keep on finding excuses. So it was approved in South Africa.